All right, so good evening. Thanks to those of you who are listening in live. I appreciate it. Those of you who will watch the recording, I appreciate it as well. Welcome to our workshop on May It Please the Court. This workshop is a new series focused on exploring the interaction between the U.S. Supreme Court, federal and state and local policy and political institutions, actors, and behaviors. Our workshop is on Tuesdays. This is our last one of the semester. So we started way back in October, and now we're at the end of it. So what we'll do is we'll go ahead and jump to case 2, which, if you recall, it's the United States versus Texas. And the key question of this case is, can the United States sue the state of Texas in federal court to prohibit enforcement of an unconstitutional abortion law? So that's the question that the court's being asked. We heard the first batch and got away to the 26 mark. And now we will start our workshop tonight at the hour and 52-second mark. So let me go ahead and open the link to this OYA website, and we'll go ahead and jump to that time, and we'll go ahead and start listening. So let's open up the oral argument, and this should be, but listen to it for about 27 minutes or so. So I'm going to jump right to here. Okay, here we go.
Between asserting that a state has structured its courts to defy federal law to completely extinguish a right, and saying that a state has codified specifically this court's holdings in the applicable case, and then also to that extent the deterrent effect has caused some diminution of the exercise of that right. That's a very substantial difference, and it's certainly a substantial difference for purposes of the judges of the courts of the states of Texas. So again, just if I may, to go back to the extraordinary nature of the kind of remedy that the federal government is seeking in this
just case. On the question of the kind of law, HB 1280, which is passed around the same time as I understand it, which is the law that the trigger law, so to speak, that has ordinary enforcement mechanisms, as I understand it, criminal sanction enforced by the state, civil. And if you pair that with this law, it looks like this law was designed to avoid the review that law kind of openly would be available.
No doubt Texas, just like every other state when passing its laws, is well aware of the limits of federal jurisdiction in federal courts, and no doubt Texas crafted its law in part because it wanted to avoid federal pre-enforcement challenges as opposed to having those challenges in state court. I agree, that's an obvious purpose of this law, or one of the obvious ways that this law functions. That having been said, Texas doesn't commit a constitutional wrong by channeling its state court challenges into state court. That is not an independent that's not an independent constitutional obligation that Texas is under. It doesn't have to sort of fly blind as far as the collateral effects of what kinds of challenges it will receive when it decides how to structure a law.
But it does have an obligation to respect people's federal constitutional rights.
Absolutely, Your Honor, and again...
So if it's attempting to stifle those rights, chill their exercise, and keep plaintiffs away from a 1983 action and ex parte Young liability, you say there's nothing wrong with that?
Your Honor, the limits of Section 1983 and ex parte Young's availability, specifically 1983, though Congress could extend ex parte Young, are a matter of Congress. The idea that Texas would design a tort statute or design a form of liability that takes that in mind and then says these claims have to go through the state tort system, the state court system. Texas judges are presumed by this court and by, for that matter, appellate judges in Texas to follow this court's precedents fully and faithfully. Texas does not suppress any substantive right by saying that it prefers to see certain kinds of challenges brought through the state court system. And to the extent that one or more Texas state court judges fail to fully apply and faithfully apply this court's precedents regarding Casey or any other constitutional right, this court is and always is the supreme arbiter of properly presented questions.
The problem they raise, and I'll just have you answer it, is they say this law is designed to avoid all judicial review because the penalties that are imposed for violation are so substantial. And then you combine that with the retroactivity provision, that people aren't going to be willing to engage in activity that's prohibited by this law. So there'll be no federal court review up front, no state court review on the back end, which is the exact ex parte Young situation. Put aside the named party, but that's the exact situation. Can you respond to that?
Of course, Your Honor. 2 points. The first one being that the procedural mechanisms, the attorney's fees shifting provision and a preferential venue provision, to the extent that those things would be sufficient to effectively deny someone access to the courts standing on their own, then there are an awful lot of statutes and tort actions that deny access to the courts on their own. I mean, another complaint of my friends on the other side in Holman's Health was regarding the lack of non-mutual collateral estoppel. Well, this court has held that there are certain applications of non-mutual collateral estoppel that violate due process. It's never been a violation of due process to not import that doctrine into a state adjudication system. So I think what we're left with here is the $10,000 potential damages award or actual damages that's doing the chilling. And to the extent that we're
General
talking —
Stone, I think it's the combination of everything. It's the $10,000 and it's everything that Justice Kavanaugh said and it's other provisions behind. And we've had a little experiment here and we've seen what the chilling effect is. Usually in these chilling effect cases, we're kind of guessing. Well, this would sort of chill me. Here we're not guessing. We know exactly what has happened as a result of this law. It has chilled everybody on the ground.
Your Honor, to the extent that we're talking about whether one or more of these procedural mechanisms might itself end up being a burden in the undue burden sense, an individual —
Please finish your answer.
Thank you. An individual could themselves raise one of these procedural mechanisms or compliance with them in the state court action and say, this particular fees provision defending this action actually is an undue burden on me because it prevents me from raising my undue burden right itself. Or perhaps, for example, a petition clause or due process clause. There might be other constitutional clauses that would protect an individual who's placed into a situation where the rules of a court itself prevent them from exercising an undue burden right. But still what that wouldn't get you is access to pre-enforcement federal review of the substantive due process right that an action under SB 8 may or may not implicate.
Thank you, counsel. Justice Thomas, anything further? Justice Breyer? Justice Alito?
If some abortions have been chilled, is there any way to determine the degree to which that is the result of the potential for SB 8 suits or from the degree to which it is attributable to the fear of liability if Roe or Casey is altered?
I don't think there's a way of being able to disaggregate those, Justice Alito, and undoubtedly individuals engaging in protected conduct that believe the protection might be removed or reasonably believe that. Undoubtedly there's an extra kind of chill they feel, but that's not attributable to the state or to anyone else for that matter.
Would the issuance of the injunction sought by the United States have any effect on liability for abortions performed after the effective date of this act?
So it wouldn't have prevention of liability. It might stop anyone from filing a lawsuit. But of course, an injunction preventing someone from filing a lawsuit doesn't prevent a state law from being effective in the event they could file in another forum or in some way they're not covered by the injunction, Your Honor.
Well, if the injunction were entered and abortions were performed, would that immunize the abortion providers subsequently from liability?
No, Your Honor. All that would do would be preventing the individuals who had notice of the injunction. First, they'd have to have an opportunity to respond before they were enjoined, but let's skip over all of those injunctive problems. Those individuals would merely not be able to bring SB 8 suits. It wouldn't somehow dissolve in the abstract liability under SB 8 for performing the abortions.
Thank you. Justice Sotomayor? No. Justice King? Gorsuch? Justice Kavanaugh?
Can I just get more clarity about how you think that retroactivity provision works? Are you saying that if an injunction were entered and some clinic performed abortions now that were then legal under current law, but the law changes in the future such that the state could, going forward, restrict abortions at an earlier time, are you saying that the state that could then reach back and retroactively, or allow suits that would reach back and retroactively impose liability on entities that were committing lawful acts as of the time?
It would be private plaintiffs again, Your Honor, but of course.
Is that a yes?
Yes, Your Honor, yes.
And is there any limit on that retroactive liability?
There might be, again, I have to hypothesize perhaps a due process claim if it were in some extreme circumstance, but no, there's nothing on the face of SB 8 that would provide it.
And doesn't that play into the chilling effect argument that was being raised, that presumably one of the concerns is even though you would challenge it today and think you would engage in the activity today because you would be confident, you're chilled by the prospect of future changes and then someone reaching back and imposing millions and millions of dollars, right?
Perhaps so, Your Honor, but I think that's
almost certainly so, right? Millions and millions retroactively imposed, even though the activity was perfectly lawful under all court orders and precedent at the time it was undertaken, right?
Undoubtedly, Your Honor.
Okay.
Justice Barrett?
Just have one question. So we're talking about pre-enforcement review and the chilling effect. So if not available, your position is it's not available in federal court, and you pointed out when you were talking to me before in the last case that in state court it's not available in the ex parte Young sense in which you could obtain an injunction that would altogether protect you from enforcement activity, but you could on a case-by-case basis obtain an injunction against individual plaintiffs. You pointed out that that might ultimately give you more protection because it would go up the chain and there would be stare decisis effect. What if, in addition to the other procedural obstacles that the law contains here, the legislature also added a provision saying there would be no stare decisis effect of any decision reached by the Texas Supreme Court?
Then, Your Honor, I would assume it would make it even more imperative for one of those cases to be taken up by this court to resolve any questions that were presented there. But that would mean that would be the only final way that you could have binding stare decisis effect.
Thank you.
Thank you, counsel. Mr. Mitchell?
Mr. Chief Justice, and may it please the Court. The interveners intend to sue those who violate Senate Bill 8, but only in response to conduct that falls outside the protections of Roe and Casey. The United States cannot seek or obtain relief that thwarts the enforcement of SB 8 in those situations. The statute contains emphatic severability and saving construction requirements, and courts are obligated to preserve the constitutional applications of statutes to the maximum possible extent. The United States also cannot seek or obtain relief that would prevent private individuals from suing under SB 8, because any such relief would be a flagrant violation of the Due Process Clause. A federal court cannot ban private individuals from petitioning the courts in a case to which they have not been made a party. And a federal court cannot foreclose those individuals from suing under SB 8 when they have been given no opportunity to defend the merits of the lawsuit that they intend to bring. I welcome the Court's questions.
I guess one would be, you've heard the exchanges with General Prelogger about the breadth of the asserted federal right.
Yes.
And she offered some answers to those questions about the limited nature, and I wanted to get your reaction to that.
Yes. And Chief Justice Roberts, as I understand the United States' argument, as they've spelled it out on pages 10 and 20 of their brief, the asserted sovereign interest that they're making under NRA Debs depends entirely on the existence of a congressional enactment, Section 1983, that does not go far enough in the views of the United States. What they're saying with respect to their sovereign interest is that Texas is thwarting Section 1983 and Ex parte Young by enacting a statute that is not subject to pre-enforcement challenge under either of those sources of law. That, to us, is not in any way a sovereign interest under Debs. That's a grievance with Congress, that Congress enacted a law, but Congress's law doesn't go far enough for the United States because Texas has found a gap in this congressionally created remedial scheme that allows its law to escape pre-enforcement judicial review. The proper response in that situation is to go to Congress and ask Congress to amend the remedies that they have set forth, either by abrogating state sovereign immunity or perhaps by enacting the Women's Health Protection Act, which would preempt SB 8 and also abrogate state immunity and give the Attorney General the explicit cause of action. But in no way can equity be invoked to patch up the holes or the perceived holes in a statute that Congress has enacted. The second issue with respect to the sovereign interest that the United States asserts surrounds Ex parte Young, because they claim in their brief that Ex parte Young does not go far enough in authorizing a pre-enforcement challenge. And that, too, runs into the problem of Grupo Mexicano. There is clearly a traditional cause of action in equity for an individual to sue an individual officer that is violating his federally protected rights. But there is no traditional cause of action or remedy in equity that would ever allow a court to enjoin the state judiciary from even hearing a case that has yet to be filed. And Ex parte Young explicitly disclaims any such remedy on page 163 when it says that an injunction against the state court would be a violation of our whole scheme of government. So what do you...
Well, but at the same time, subsequent cases suggest that that language can't be read as broadly as you suggest. Shelley against Kramer, Terry against Adams, some of the others where they've recognized that courts can be viewed as a part of the mechanism of enforcing particular rights.
That's true. But in neither of those cases that Your Honor cited was there an injunction directed at the state judiciary itself. And under Grupo Mexicano, equitable remedies must be limited to those that were traditionally available in equity. And Ex parte Young makes clear that a remedy that would enjoin or restrain a state court or a state judge from even considering a case is not a remedy that was traditionally available in equity. So it's impossible to escape the conclusion that this relief requested by the United States is barred by Grupo Mexicano.
Well, Grupo Mexicano is notoriously cryptic. But Shelley against Kramer, Terry against Adams, they aren't really. I mean, if you look at Justice Frankfurter's opinion in Terry, he says, somewhere, somehow, to some extent, you have to have some participation. That seems like a pretty flexible standard.
Well, again, in Terry against Adams, their cause of action was undisputed. The existence of an Article III case or controversy was undisputed. And those are the two obstacles here that the United States must confront. So the fact that there is case law out there in which relief has been granted in similar situations, involving situations where there was no question of the existence of an Article III case or controversy and no question of the existence of a cause of action, does not give any leverage to the United States' argument here, when the very objection we're making is that they can't bring suit because there's no Article III case or controversy under Muskrat, and on top of that, they can't bring suit because there's no cause of action in equity, because the relief they seek is not relief that is traditionally available.
Well, there is an Article III case or controversy with respect to the clerks, right? It's a direct adversity. The clerks want to file the action, and the plaintiffs don't want them to.
True. But the clerks aren't the named defendants in this lawsuit. Only the state of Texas is. And under Muskrat, you cannot sue the sovereign entity when your complaint is that the sovereign is allowing its courts to adjudicate cases under a statute that you believe to be unconstitutional. It would be no different from the abortion providers suing the United States government because they're allowing SB 8 enforcement lawsuits to be heard under the diversity jurisdiction. There wouldn't be a case or controversy with the United States simply because it's opening its courtroom doors to these claims. What they would have to do is wait for the cases to be filed and then assert their constitutional challenges to the statute in that litigation between the private citizens.
Do you agree, to follow up on the Chief Justice's questions, that state clerks, court clerks, and state judges enforce state law when they entertain private civil suits?
No, I don't believe they can be said to be enforcing state law in those situations.
How do you deal with all the language in Shelley versus Kramer that uses the word enforce?
Because I think in that context, enforcement is coming after a judgment has been entered by the court, and then the judgment is being enforced. But simply adjudicating a case at the outset and simply docketing a complaint, that is not enforcement. And this goes to another problem with the remedy that the United States is seeking with respect to the private individuals. They're asking the court to restrain Texas from adjudicating lawsuits. They want to stop the clerks from docketing the complaints. They want to stop the judges from hearing or presiding over the cases. And then they say that injunction should extend to private individuals under Rule 65D2C. The problem is the private individuals aren't doing any of those things that the state has been enjoined from doing. They're doing something entirely different. They're the ones who are filing the lawsuits. And the state can't file the lawsuit because it's not allowed to file it under the statute, and it therefore can't be enjoined from doing so because an injunction against the state that tells it not to file a lawsuit is enjoining the state from doing something that it never would have done in the first place. So there's another major problem with trying to get private individuals covered by this injunction that the district court laid out. The only conduct that private individuals are engaged in is conduct that the state of Texas is not.
Counsel, a state is an idealized entity. The whole fiction of Ex parte Young, it had to be created because a state qua state can't act. It can only designate people to act for it. And so if the state is designating whether it's ordinary citizens or the Attorney General or its district attorneys, if it's designating those people to act for it, why aren't those people bound by any judgment that says, state, what you're doing is unconstitutional?
They would,
and no agent of yours can enforce this law, whether it's ordinary citizens, the Attorney General, state licensing officials, clerks of court, or, as Shelley recognized, a court system that would enforce a restricted covenant demanding segregation. Why aren't we in exactly that same position?
They would be bound if they can satisfy the test of Rule 65D2C, which says they have to be acting in active concert.
Why? They are.
No.
Each of them is acting under the directives of the state law. So why aren't they acting like the state when they act?
Justice Sotomayor, I respectfully disagree with that characterization.
I know you disagree, but
I'm going to explain why I disagree with it. The state is not in any way directing the activity. May I answer?
Please.
The state is not directing the activity of these private individuals. The state has passed a law that gives them the option to sue, and then it has washed its hands of the matter. So there is no joint participation with the state in their decision.
How is that any different than there being state action when a prosecutor exercises a discriminatory Batson challenge? Or how is there state action when state primary actors exclude races or exclude people from primaries? And we've called that state action, even though the state has just given them the authority to act with no control over what they're going to do.
Right.
So we have recognized that that washing your hands doesn't insulate a state.
With your example on the prosecutor.
Or insulate people from acting on behalf of the state.
Yes. The prosecutor, in your hypothetical, is an employee of the state. He's part of the state government. He's part of the machinery of state. The white primary example is a more difficult question because they were formally established as a private entity.
Are you suggesting that states can hire agents to do unconstitutional acts?
No, they cannot hire agents.
So how can the state designate a private individual
because
to act on under its laws to violate a person's constitutional rights?
Because there's not an agency relationship here, Justice Sotomayor.
It's saying to it, you under this law, our law, you can act.
I see my time has long expired. May I continue to answer? Or
briefly.
Yes, I'm sorry. Justice Sotomayor, if there were an agency relationship, then Your Honor would be correct. Be bound by an injunction under the principles of Rule 65. But there's no agency relationship here because the state is statutorily forbidden to enforce the law or have any enforcement role whatsoever. That role is given to private citizens. The state can't have any involvement, so there can't be joint conduct with the state with respect to that particular activity.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Justice Barrett? Thank you, counsel.
Thank you, Your Honors.
Rebuttal?
Thank you, Mr. Chief Justice. I'd like to just make 3 points in rebuttal. And I'd like to begin with the point that I understood General Stone to be making, that if this court ultimately concludes in Whole Women's Health that the providers can sue, that the authority we're claiming here to sue as well is extraordinary or unprecedented. And I think it is important to recognize that when the United States of America filed this suit to try to redress the harm to the supremacy of federal law in Texas, the Whole Women's Health providers had not been able to obtain any effective redress from the courts. The law had been permitted to take effect, and it had immediately had its intended operation of chilling the exercise of constitutionally protected conduct altogether, so that abortions that are protected under Roe and Casey after 6 weeks of pregnancy could not occur at all. And I think that that shows the threat to the supremacy that comes from this attempted design of a law to block access to the judiciary. It may well be, and I hope that this court holds in Whole Women's Health, that the providers can move forward, but that hasn't stopped the harm to the sovereign interests of the United States in the meantime, as Texas has succeeded, while these novel issues worked their way through the courts, in blocking access to care that is protected under this court's precedents. And that leads me to my second point, which is to emphasize the nature of the sovereign interest here. It is in preventing a state from being able to act in direct defiance of this court's precedents and block access to the judicial review that Congress and this court have deemed necessary to vindicate federal rights, and to further make it the state court mechanism that might provide some alternative basis for raising those constitutional claims wholly ineffective and unavailable. The final point is to just step back for a moment and think about the startling implications of Texas's argument here. Across the arguments this morning, Texas's position is that no one can sue, not the women whose rights are most directly affected, not the providers who have been chilled in being able to provide those women with care, and not the United States in this suit. They say that federal courts just have no authority under existing law to provide any mechanism to redress that harm. And if that is true, if a state can just take this simple mechanism of taking its enforcement authority and giving it to the general public, backed up with a bounty of $10,000 or $1 million, if they can do that, then no constitutional right is safe. No constitutional decision from this court is safe. That would be an intolerable state of affairs, and it cannot be the law. Our constitutional guarantees cannot be that fragile, and the supremacy of federal law cannot be that easily subject to manipulation. So we would ask this court to hold that the United States can proceed with this action and affirm the preliminary injunction entered by the district court and immediately vacate the stay that the Fifth Circuit entered in this case, so that Texas cannot continue to deny women in its borders a right protected by this court's precedents one day longer.
Thank you, counsel. The case is submitted. We'll hear.
All right. So that concludes the oral arguments for the United States versus Texas. And just two things. First, there's obviously a lot of terms. I've been writing things down, like traditionally available in equity or federal right, or what I found most intriguing was this gap in congressionally created remedial scheme. All in all, this is a very fascinating case. My expectation is that it'll be decided maybe before the end of the year, but given its particular complexity, it might take until next year. But overall, I hope you found this case interesting, the one prior to it, Tennessee versus Mississippi, interesting, and just the whole process of learning about the courts, very interesting. So with that, thanks for listening in, and we'll go ahead and stop the recording and get to a brief discussion. And take care and have a great night.